All right, great. Well, let's go ahead then and maybe get started. And if we get some more late stragglers that come in, I will continue to drop the link for the office hours in the chat. So thank you guys very much for joining today. This is going to be our second and final session to date, talking about US EU intellectual property strategies for folks that are just generally interested or considering a market entry into the EU for their biotech startup or product. And this is hosted with Nucleate and Vossius, who's one of our incredible sponsors in Europe, doing a lot of work on the intellectual property side for a lot of our great alumni teams. And we have the pleasure as well of being joined by one of those teams today, represented by Tilman. And in a minute, I'll give him a chance to introduce himself and tell you guys a little bit more about his startup. But my name is Oliver. I'm the co-founder and chief operating officer of Nucleate. And it's my pleasure to be joined here today by all of you guys on the call to discuss this very exciting topic. I think maybe we can start with a quick round of introductions, and then we'll get into some slides that I think Richard will present, sort of talking about, maybe like a quick refresher on some of the basics in terms of the differences between the US and the EU, and then maybe a little bit more of a focus on sort of litigation differences between the two countries to kind of give an informational overview as you guys are considering what those intellectual property considerations might be if you're, in the US and thinking about doing, or a different country and thinking about doing an EU market entry. And then we'll open it up to a fireside chat with Tilman and the Vossius team to talk about his technology and very exciting biotech startup, and also his journey from the lab to the startup with a focus on the IP and sort of all of the considerations that he had to think about there as he was spinning out of academia. And then we'll open it up to your guys' questions. We'd love to hear your questions, take your questions. If you have questions during the slides or any other portion of the chat, feel free to just put them in the chat, and then we'll address those questions in the order that they are asked. And then at the end, we'll open it up to sort of an open Q&A where you guys can unmute as well and voice your questions. So without any further ado, I would love to pass it to Richard to introduce himself, and then we can just popcorn through the rest of the panelists. Go ahead, Richard.
Hi, thank you for inviting us to participate today. My name is Rich Enman. My background is in macrobiology and cellular engineering. I've been a patent attorney for now over 20 years with US, a firm. I started in the US and then I came to Europe in 2009. And became a European patent attorney as well. So I have feet in both worlds and have been now a partner at Vossius. And I'm happy to help in any way I can.
Okay, maybe I jump in here. Oliver, thanks a lot for the introduction. My name is Andreas Heiseke. I'm a partner in the bio department here at Vossius. I'm located in Munich. We also have offices in Switzerland, also in Germany, in Berlin, and in Düsseldorf. The headquarters is in Munich, where I'm located. My work is in the life science field, particular molecular biology and biochemistry. I'm a German patent attorney and also a European patent attorney since 2015. And yeah, as Rich mentioned, we are more than happy to help anybody. So nice to meet everybody, and maybe I pass on to Anna.
Hey guys, nice to meet you all. I'm Anna. I'm also located in Munich and I'm part of the biotech team at Vossius, although my background is in mechanical engineering. And since last year, I'm junior associate and European patent attorney at the firm.
Okay, that's finally my turn. My name is Til Schlotter. I am a European and German patent attorney. Before I joined Vossius, I studied biochemistry, did my PhD on a biophysical topic, and also microbiology, molecular biology, and all that. These things. In my practice, I advise startups, companies, academia, but also medium-sized and large pharma companies, and essentially everything related to biotech and life sciences is within my scope of work. I also do AI-related inventions, which become increasingly relevant in the past. Thank you.
Nice. Then I'm the last, I guess. I'm Til. I was actually born in Munich, but live half my life now about in Zurich, where I spent all my studies in mechanical engineering in the beginning, then more biomedical, then a PhD in bioelectronics, nanotechnology, where I developed a novel nanopore system for protein analysis. And that's also what UNOMR does and what we're currently further developing. Also with the help actually of Vossius, who help us define a bit our IP strategy.
Amazing. And I believe that's everyone. Although if we have other folks that we missed, please speak up. And then I will pass it off now to Rich to give you guys a little bit of a slide presentation informational overview. And again, if you guys have questions, feel free to drop them into the chat.
So I will believe this is it. Okay, so if you joined us last time, we talked to some briefly about the drafting of patent applications. There are some considerations that people may have coming into the Europe or the United States and some of the differences. And then we heard that maybe some people were more interested in litigation type subject matter. So I'm actually going to start with the litigation type subject matter today. And as Oliver mentioned, if you have questions, feel free to drop them in the chat and we can try to get to them either during our discussion or after. This is a brief introduction about Vossius. We're one of Europe's leading IP firms, and as Andy mentioned, we have offices throughout Germany and Switzerland and handle all European cases before the European Patent Office and or the UPC, which is the United Patent Court. This is also a brief introduction of who we are. Dr. Marchand, a colleague of ours, unfortunately cannot join us today. And this is the QR code, which I believe is still active, hopefully, for the one-on-one meetings. It goes over the calendar, I believe, app. So we are focusing on patents today, but when you're considering intellectual property, it's actually much more than patents. So intellectual property can be, you build a thicket to best protect yourself with copyright. You can also have designs, which can be separately protected other than patents. We can have trade secrets and trademarks. And so depending on what you're doing, patent may or may not be the right choice for you, but that is something that you can discuss with a patent professional. So there may be other options. So don't think that you're locked into this patent type world. There are other options to protect your intellectual property. That being said, now I'm going to just briefly discuss like litigation type of actions that you can take. So if you're a startup company, something that you may be interested in pursuing, whether or not you're in Europe or the US, and I'll mention some differences. One, I think this is of limited interest, but a litigation type is an inventorship dispute, so that if you think that somebody has stolen your invention in both the US and Europe and in all jurisdictions of the world, there are normally separate and specialized proceedings to deal with allegations of incorrect inventorship, so that you can basically sue someone. It's not, depending on where you are, it's not a suit, but you assert that you should have been an inventor. And you can normally do this during examination of the patent application or even after it's been granted. Normally, they tend to be a little costly because it's very data intensive. And if you're going to do this, you want to do this while it's still being examined because normally it's less expensive. If you're a patentee, and again, I think this is of little interest because obviously if we already have a patent, we're not talking about being in this round. To assert a patent against third parties, you can assert a patent against third parties basically for any reason. Although you have to have some kind of, at least a minimum of evidence that they are in fact infringing your patent. The actual rules for this can be country specific, as is the patent. Patents are just because you have a European patent doesn't mean you're protected in any other country or any other jurisdiction. In the UPC that's recently come into force, the United Patent Court, Previously, you had to sue in individual countries, France, England, Germany, what have you. Now you can proceed in the UPC. There are a little bit of some formalities you have to check to see if it's still available for you, but you can proceed in the UPC, and then that makes a decision for all signatories of the UPC, which are most European countries with the exception of Spain. But these do tend to be very expensive undertakings. So $500,000 is not unusual for something like this. So if you are you're a startup and you've got a product out there, and most of the time you're watching the patent landscape and you think that somebody is going to be problematic for you, what can you do? So one of the things you can do is file third-party observations. These normally cost no money, so there's no official fees associated with that. You have to think about maybe attorney's fees, so you know what you're doing. But basically, these are letters to the patent office that says, hold on, I can see what's going on. Most patent proceedings are public knowledge. You can see what's going on in the registers of the particular countries. You can say, look, what's going on? You're missing something. You should really be considering this other art. In the US, has a very defined time limit to do it. You have to do it early in prosecution. With the EPO, there's no time limit. There are some caveats to these, unless it's clearly novelty destroying. Most of the time, it rarely affects prosecution. So you're really not going to kill a patent, again, unless it's very clearly novelty destroying. And the other thing you might want to consider is that it can prejudice the use of the documents that you use as evidence later if you want to attack them in court or in opposition proceedings, basically with the idea that these courts or this other administrative body will say, look, you already presented, these documents were already considered in an examination and they were considered irrelevant. Why should we worry about them now? You can also wait till after the patent is granted. In the US, they did institute recently, well, 2013, post-grant proceedings, which you can institute under a variety of reasons. Anybody can do it. They tend to be very, very expensive, over $10,000 in official fees, but they're less expensive than standard litigation, and it goes faster than standard litigation. The one caveat, also other than the money, is that there's no guarantee that it's going to be accepted. That means you file it and you say, I think the patent needs to be looked at. The patent office looks at your information and decides to proceed with the proceeding or not. So there's no guarantee that it's actually going to work. And sometimes you're limited in what kind of arguments you can bring. In the EPO, there's an opposition, which is also a post-grant proceeding. It has to be filed within 9 months of grant, but we're at least an order of magnitude less expensive than US proceedings. To actually file it, it's only a few thousand, and then you have to worry about official attorney fees, but again, it's much, much less expensive than the US. Finally, when you get into real litigations, there we're talking about big money to challenge the validity of a patent. In Europe, anyone can challenge it for any reason. The invalidity and or infringement can be separate or joined. And again, with the UPC that came into force, it eases these procedural hurdles. You don't have to go in every country. You can go to a single court proceeding. You can also join the infringement and validity into a single case. And you can also sue for declarations of non-infringement. So you just say, hi, I'm doing this action. Can you please tell me whether I infringe this patent? This isn't available in the US. In the US, you have to have standing to sue. That means you have to have a reason to challenge a patent. Normally, how you do this is either you are under threat of suit from a company and the company sent you a letter and has said, okay, stop what you're doing, or I'm going to sue you. Then you can sue back. Or you can force it. You can write the company a letter saying, I'm going to do this. What are you going to do about it, basically? And then the company will respond or not respond, but it can give you a standing to sue. And but we're talking millions of dollars in a standard litigation in the US. So what's of most interest to probably everybody in this forum that we're talking to now are freedom to operate opinions. You may have heard of these opinions. These are something that are prepared by patent attorneys that basically say whether we believe you infringe or don't infringe certain patents. Most of the time they're dealt with searches. You come to us and say, I'm thinking of entering the market in Germany. I'm thinking of entering the market in the UK. Do I have a problem or not? In Europe, basically what they're for is they're for investors. We prepare them and then you can give them to investors and say, look, I've got basically a clean bill of health, or there seems to be problem X, Y, and Z, but we think there's ways around it. And these can be really tailored to what your needs are. Do you want a global overview? Do you want to consider certain patents? Do you want to consider certain questions? And they can be useful in an infringement suit. So if you are sued for infringement, then you can say, look, I already have an opinion. I didn't think I was infringing. And so you're already basically have a presumption of innocence. In the US, the same thing happens. You get all of these advantages. Plus, what is a significant advantage in the US is that if you are sued and found guilty of infringement, there's a standard of knew or should have known. That means if the court decides you knew or should have known that you were infringing, whatever damages come at the end of the case, and normally in the US, damages are very, very high, they're automatically multiplied by 3. So you have treble damages because you knew or should have known. However, if you had an FTO opinion before the suit starts, where it says, okay, we don't think you infringe this patent or these groups of patents, treble damages are not asserted. There is a caveat that these can't be just sort of paper opinions. They have to be well researched. They have to be prepared by a US patent attorney. But they can be costly. Normally they run into the hundreds of pages, and about $100 grand is what you're looking at, but they can be more expensive. So that was my warp speed overview of the types of litigations. I don't know if we have time for me to go into some other topics that we talked about last time. Oliver, what do you think we can end it there and
Yeah,
then
I guess
continue?
my just one question I would ask, for this audience, I imagine, first of all, no one wants to go to court, right? That's how you've lost if you've gone to court, right? So the strategy and how you want to do things is to be very extremely proactive. So I guess from your perspective, I guess two things. One, what are the common mistakes that you see that potentially risk litigation in the future that founders make? And then two, what would be your advice for founders at the start of their journey to sort of consider litigation? Because obviously there's a lot of things to think about from an IP standpoint. So what's kind of like the quick hit list of like, be very careful about XYZ, right? So for example, FTO, like you mentioned, doing an FTO is going to be really important to, that'll affect potential damages down the line if you do go to litigation. But even more basic than that, do you
Right.
have, sort of the do and do not list for people when they're thinking about how to avoid litigation?
Right. Well, I think one of the very first things you can do is there is software, or even on some of the patent websites. So the European Register has tools to monitor certain patents. I would certainly, if you're entering the field, you need to have at least a broad overview of what's facing you. So I think investing in a patent search is a very wise choice. These searches can be tailored or broad depending on your budget. Most of the search firms that we work with are very cognizant of costs, but at least it can get you an idea of what you're potentially facing. And also get you a list of potentially relevant patents, and you can watch what goes on in those patents. As I mentioned, I think that's basically the do not side of it, right? That you cannot go into these things blindly, because if you're looking at inventors for investors, investors will do their due diligence before they give you any money. And so if you don't know what's out there, they will definitely find it, and you don't want to be surprised. For positives, you need to monitor what you really think is going on. You need to monitor the patents that you think are problematic. And you can talk to at least have preliminary conversations with a patent professional and to alter strategies, because maybe there's a patent that seems to be problematic, but it might be of limited jurisdiction. So maybe France is off the table for you, but somebody else, some other jurisdictions might be available, US or other countries. And the other thing you need to really be careful of is when you start publishing. So you're going out, you're looking to get investors, and you don't want to advertise what you're doing before you have some kind of protection in place. Because obviously, if there's big money, that's a potential competitor for you, as soon as you start trying to enter the market, they're going to come after you.
Brilliant. Okay, sounds good. So we're at 11:30, so maybe we can move on, unless you had any other points that you wanted to cover. Great. Okay, well, it is my pleasure now to introduce Til. So Til, do you want to just sort of tell people a little bit about maybe your technology, what it is, how you thought of it, what stage you're at, and a little bit about yourself and sort of your founder journey? I think people would be really interested to hear about some of those things before we dive into all of the nitty-gritty relating to the IP.
Sure, sure. So yeah, very shortly about UNOMR. We are a startup from ETH Zurich. We are at the moment not the biggest team, so we are 6 postdocs, some students. We're very lucky to get some non-dilutive funding. We could secure about 1.2 million. That helps us to build our sensor. It's about 2 years ago now that I finished my PhD. During that PhD, I was researching on novel nanopore system. So we provide a sensor to customers mostly in life science and pharma and biotech and food tech who want to measure protein modifications. And this nanopore sensor is special in the sense that we call an interface nanopore, so it can adjust its size, and we can put many of these pores in series, which helps to reread single proteins many times, not only once, like some of you might have heard of Oxford Nanopore, who do DNA sequencing with nanopores. So we're targeting a bit in a similar way, even though we think that protein sequencing is still a bit ahead. So we're going step by step and do single modifications, currently with a focus on protein glycosylation. And for those who are not molecular biologists or so, neither am I. It's really useful because 90% of all epithelial tumors are associated with protein glycosylation. Mass spectrometry, which is the current gold standard, can often not resolve the type of glycans nor the position of glycans, nor is it single molecule. So there's a huge potential in novel precision medicine approaches, but also in diagnostics, even though we are mostly focusing on R&D actually. That a bit about UNOMR. Having said that, we were actually just recently, since very recent, we are alumni of Nucleate. So we just were part of the last cohort in Switzerland, where we actually also got to know Vossius. Interestingly, one of our former colleagues of our lab, he now works at Vossius. He was a former entrepreneur himself and co-founded a startup also in Switzerland. We're doing stretchable electronics called Nanolec for, I don't know, I think it was a brief measurement mostly they did, and he joined Vossius as a patent attorney. So that was a great coincidence, but also, of course, build some trust if you already know someone in that company quite well. To start then your journey, also not only building a technology, but also trying to save it a bit or to protect it. In a sense, as you might have heard, proteomics and single molecule protein analysis is a decent hot topic at the moment. So of course, we're not the only ones. There's other startups in the world out there who are also looking to the proteomic space. And therefore, I think it makes sense to have a good patent strategy. I think we're very unique with our approach of a very completely new way we actually do nanopores and the way we sense nanopores. And our approach to decompose a complex molecule by measuring it in different nanopores consecutively, but still kind of this uniqueness you want to protect. And yeah, that's pretty much about us.
Amazing. So can you talk a little bit about sort of when you were starting to spin out of the lab, sort of what that process looked like, some of the challenges, some of the things that were exciting, and in particular, sort of how you thought about the IP and sort of what that process was like for you as you were thinking about transitioning from an academic project into a biotech company?
Yeah, so we, as I said, I finished my PhD 2 years ago, and that's also when we kind of started the startup story. We already had a patent that was quite old with ETH. So I guess as most universities, they have some technology transfer offices that usually, if you're incorporating or founding, you in biotech at least, you potentially have a patent that you want to license out. So one part is, okay, how do you get your license from the university? And already there, like it didn't go that well for us in the beginning. So I mean, I guess the lesson learned is that tech transfer offices are good in writing patents, but they don't know which patent in the future will be used for a startup. So I guess first recommendation in that sense would be, as a founder, you should always care about your own patents and not rely on tech transfer. But really keep in mind, well, you know what patents you need, and you should try to care about it. Going through different phases. So as you heard before, in Europe, there's a European patent application before you then go to the PCT application. It's kind of an international one. And there's all these phases that you go through. And I think as a founder, you should always take care of it yourself. And then you come to the point where at some point you want to license out the IP from university. ETH is doing, I would say, actually a decent, good job. They try to give good conditions to startups to support their own startups. It's also good for the reputation, of course, of the university. And I mean, like, you have to negotiate, but I think it makes sense to try to tell them, okay, you want to license this out and negotiate as soon as possible. And preferably, ETH has it now, you even have standard terms. So I know that EPFL Lausanne has it as well. I know some German universities are a bit more not straightforward. And I heard in the US they also want to have often a lot of equity actually from other founders. But I think that you should have in mind. And we're still at the university, so it makes also sense to think about, like, if you're starting a journey of founding a startup, really trying to get this help still early on from university helps a lot, like being able to use labs, get support of your PI, and so on.
Totally. So I know that you mentioned something about the sort of university didn't really sort of pay attention to how the patent was written. Like it wasn't quite written the way that you had wanted. Can you talk a little bit about sort of how you figured that out and then sort of how you address that in the context of your startup? Like what strategy did you develop and at what point did Vossius become a part of the process and the journey for you?
So I know we have 2 patents now, but we then said, okay, let's drop the first one because it was quite old and quite generic and focus on the new one that we have. We can actually implement more innovation and more detail that we did compared to the first one. I think universities usually want to be very broad in their patents, which makes it also not that easy to defend in the end. So now the strategy is really to specifically focus more on how do we build our sensor, what's key aspects that can be patented compared to, of course, it was also my first patent and I did it in my first or second year of my PhD or so. So the way it was written, I think, was quite different than the new one that is written now that we were just filing this year. And in our case, we have one patent lawyer that basically we were given by the university to patent. So we worked with them on writing the patent. But we had the impression it's good to have a second opinion on it. So we said, okay, in order to do the patent strategy, we actually want to have another office, another patent office that goes through the patent and, always 2, 3, 4 eyes see more than just 2. So we said, okay, let's work with Vossius. And we started that also more recently. So like, I guess in May or so, or maybe a bit before that, it was actually during a Nucleate session that we met. And yeah, since then, like they look through our patent with a different perspective. Maybe what I like about them is that they have it's a huge company. So I think you have 300 people or so, no? Or 200 and 100 patent lawyers or so. So they have an expert for every topic and niche. And I liked that they really tried to understand our technology and then see, okay, now we're still in the phase where we can do more filings. Within like the first year of your patent, you can do more filings and also then have an idea. Do we want to, for example, have 2 or 3 patents in the end out of one, or do we write an additional patent? I think that's a very nice collaboration. I enjoy.
Brilliant. Oh, Richard says he has a comment on this topic. Anyone can feel free to break in at any time.
Yeah, I just couldn't figure out how to raise my hand. I don't know, but there were two things that Til mentioned that I think is very relevant for the audience. One, he talked about getting the license from the university, and people as a startup, it can be that people begin their invention or begin thinking about doing a startup as they're doing their PhD. I just want to not caveat, but you need to be very careful about your work contracts. And depending on where the university you have, because just because you think you're developing something outside and independently, some of the work contracts for universities can be very, very, I guess, aggressive with IPs, and you can run into trouble thinking that you own something when under the contract, it looks like the university owns it. So look at your work contracts, look at anything you sign, because you don't want to sign away rights that you don't think the university has. Then about the initial application, some people, there are several stages of the application process, as Til mentioned. Usually you start with a provisional application or a priority establishing application. This is an application that you write, and basically it becomes a placeholder. It's not examined. And then this needs to get turned into a regular application later. To mention, it's a PCT application, sort of an international patent application. There's sort of conflicting information running around there that you can add information at the PCT stage. And so you can file, basically change your application. This is true in a sense, but there can be several disadvantages. If you add too much at the PCT stage, you could lose your priority. So you want to do the best job you can at the very beginning. And as Til mentioned, he didn't think that the original draft, the people that were drafting the application did a very good job. This is a sign for you. If the person that's drafting your patent application isn't bombarding you with questions, really aggravating questions and seemingly pointless questions, get another patent attorney, because it's that way we figure out what your invention is, and our job is to really expand this out into the broadest scope that we think is possible. So sometimes we're going to ask really stupid questions, or what you think are stupid questions, but it's really our way to figure out what can we make out of this. So you want somebody to be really aggravating. If somebody just comes back to you, never talks to you about it, with here's the draft, dump them and find somebody else.
Maybe I can jump in here and add one more thing. So when you make your invention, that is also what we see a lot, is that you should be careful what you are publishing before you file an application. That is actually also a very important point. So when you publish your invention, you will in all likelihood not obtain a patent anymore. So talk to the patent attorneys before you wish to publish anything. That is also very important. So then we can have a look at it, decide whether or not it's worth applying for a patent or filing a patent application, and then we can also draft quickly so that you can publish, because you also want to publish it. That's pretty clear. You want to commercialize your invention, of course, but don't do it before you file a patent application. That is, I think, an important advice.
And it's not just publication. So these are also talks, or putting an abstract in a meeting journal. Abstracts are published, or talks. Anything where you publish for a patent attorney means anytime you make it public in whatever form, posters, what have you.
Actually, something very interesting I learned by Philip was that there is like some conferences that say they're kind of confidential, like GRCs or so. And actually, stuff that you show there, I learned, is still patentable. So because nothing is published in Volotech pictures and so on. So you could even, if you want to talk with the community, use that as an opportunity before patenting. I don't know how much is recommended. I didn't do it, but I heard at least that in principle, they count as a...
Yeah. In principle, it's possible, of course, but you never know what the people are doing. So if somebody just runs around and makes photos or so and distributes it, you cannot sue this person, even if there's no money for you to get from this person. It's published anyway then, so it's a bit risky. So I would not recommend it, actually, but it's in principle, you are right, Til, of course.
There was a question about, is it only in the EU? It is true that the EU has a very draconian rule that anything published before your filing date can be prior art. Other countries have what's known as grace periods, In the US, it's a year. In Japan, it's 6 months. So there are outs that if something gets published, or if you publish something without talking to a patent attorney, it may be possible to file in other countries. You don't want to do that. That's not the optimal route that you'd like to keep everything silent before you file, but it is possible if something went out that you didn't know about, or if you just didn't appreciate it, there are countries still available to you.
Great. Yeah, definitely always patent everything first. Do not just best practice there. Don't prior art yourself. That's the most painful thing that can be done. Cool. So I guess, do we have any questions from the audience? Feel free to unmute or drop your question in the chat. I think we've heard a lot about Til's story and sort of all of that stuff. And oh, we've got one from Sarah again. Can you guys comment on PCT filings being abandoned? Is that common in startups? And I guess maybe even just for those who might not know what that means, what does it mean when a filing is abandoned?
Well, you can abandon filings. So when you file what I talked about before, typically people file a provisional application. These can be filed for very little money, depending if you want a search report or not. So you might want to see what the patent office thinks about an application to see what you're facing. Typically, though, a PCT filing becoming abandoned is kind of late, so that you've already invested some money, and you would only want to abandon it before it gets published. If you have a priority application and then a year later you file your PCT application, you only have 6 months, because the PCT application will publish 6 months after filing normally. And if it publishes and then you abandon it, you basically now, as Oliver said, shot yourself in the foot, because your invention has now been made public. And that can be very problematic.
There's another question in the chat. Damages calculated. Yeah, how are damages calculated? And I guess how much do you have to worry about that or think about that at the early stage?
I'm much more familiar, because damage calculations are very country specific. So that when you infringe in Germany or you infringe in France, they all have their rules about how damages get calculated and what are damages. I know about the US, and so my colleagues can comment on Germany, but damages in the US can be very high, because it's not only potential lost revenue, but its future revenue is also calculated. And because the US is a very large market, they consider it as if you had gone into the entirety of the US. And so you have that whole entire market available to you. So damages can be very high, but it's a specialty. There are attorneys that are specialized in that. It can be very hard to calculate, but at least in the US, they're high.
Same in Germany. So as Rich mentioned, so we also have attorneys at law who are more familiar with it. But what is usually done in Germany, especially, is that you calculate the damages based on what your infringement action caused for a loss of profit for the IP holder. And so they have to calculate and show how much they lost, and that is a damage you then have to pay if they get the if you are sued, of course. So that is one possibility. But it's a pretty complex topic, how damages are actually calculated.
One typical way in Germany of doing this would be, because sometimes it's hard to estimate revenues and all that, would be a kind of a license analogy. So you would calculate it as if you would take a license on that patent. So that makes it a bit easier, because for licenses there are some known percentages or typical percentages in different industries that are typically used, and that makes it a bit easier to for the court to define the damages that are awarded. But the typical situation would be that there will not be a final judgment because parties will settle long before the court's final verdict on the damages will be issued.
Nice. Sarah also asked, is there a penalty other than losing the priority date? Was that in reference to like prior arting yourself?
I think that was question was dropping the PCT. So
Okay.
the penalty is, so if you abandon your application or withdraw, you can either, well, a provisional you can normally abandon, you just don't do anything else and it just sort of dies on its own. Or you have to be careful if you have to actively withdraw it. When you actively withdraw before publication, there's no penalty because nobody should be able to find it. If you file the piece, yeah, I think before publication, nobody would be able to find it. And so then you would be okay. But after publication, then you prior art yourself.
Exactly. Do we have other questions from the audience?
So just one comment, if nobody's asking questions, with regard to your patent application, just remember that your patent application is going to go into every single country. You have one patent application for worldwide that you're going to use, or typically that's what you need to do. You only want to invest the money once. So you need somebody that's going to look at the requirements, not only in Europe or US, or depending on where they're drafting, but all jurisdictions. So that's also important. And you want to make sure these are questions to hit back at your patent attorney. And remember, you're controlling, you're spending this money. You can be aggressive with us. We can take it.
Maybe I also have another comment, maybe a bit different than what patent lawyers would say. But personally, as a founder and as an entrepreneur, I think as a young startup, it's very difficult to kind of really defend your patent. And I think the reason why we succeed is because we're faster and better and we're implementing faster, so the others don't catch up. So to me, it's more really important for investors because often investors want to see, do you have IP? Plus, then maybe in a later stage, like maybe not in a very early startup, but if you go more for around Series A, B, C, then I think it becomes also more important. To be honest, personally, in the beginning, I would file the most important patents, but probably not focus too much on it and rather try to be fast because as a young startup, we don't have the money to really defend it, I guess, in the end.
So there's another question in the chat. So I think when you have a part of a large system and you want to find out whether somebody infringes your patent, then you can buy like a purchase this larger system, and then you really have to disassemble it and look whether or not there is what you are protecting with your patent. That is also what is frequently done. So you buy things that others sell, and then you survey whether or not they are really infringing what you have patented. So that is usual course of action.
And the other thing I want to mention is if you say you patent a piece of something, and somebody patents a larger system built around that, they are perfectly free to patent that. If it builds something else and you're just a piece of their puzzle, your piece of their puzzle is part of the public knowledge, and so they can improve upon that or use it, and they can patent that. Now, the caveat is they might not be able to use their invention without paying you money because they need your piece, but they're still free to patent it. I don't know if that makes sense, but
It seems to have answered the question. Are there any more questions from the audience that you guys have? And I'll also just remind people again, if you want to connect one-on-one, there are free office hours that are being offered at this link. I just put it in the chat again. It's a great resource. Definitely take advantage of it. The team would love to dive in a little bit more deeply on your specific topic in science and help address whatever questions might be coming up at your startup, or even if you're just at the early stages spinning out of academia. I'm sure they can speak a lot to the licensing process and give you some tips and tricks there as well. So I'll open it up. Oh, okay, here we go. For a startup that is still very early stage, what would you recommend as the best approach to start protecting our intellectual property, especially if we haven't finalized the product yet?
So
I mean,
maybe
also,
at the big,
sorry.
Til, you go, please.
No, maybe also there, my personal, or also what I heard and what makes sense is that patents can become expensive at some point. So if you don't have to publish and don't need to patent, I would try to wait as long as possible. That would be probably the best advice. And I don't know how the patent lawyers see it. They want to make money in the end, but still, you should wait a bit. And yeah, and from there on, I think what you really have to patent is your uniqueness. I don't know whatever system you build, but really focus on what do you do different than the others and try to focus on that and try to get the long-term protection then for this.
Yeah, sure, that's completely right. So then if you don't have the money and you're a very early stage, then keep it secret as far as possible, of course. Yeah, and when you have the funding, of course, it's always a thin line to decide whether or not you wish to file a patent application. But at the beginning, it's maybe better to just keep it secret.
Right, and as I mentioned at the very beginning of the presentation, patents aren't the only way to protect something. There's a very well developed concept, trade secret law, that can allow you to keep certain things secret while you're actively using them. So patents aren't the be all and end all of IP protection.
Maybe there's one more thing. I learned actually also from Philip that if you have trade secrets and you kind of document them, if someone patents you, you can always show that you were doing this already before. And then I think there's this right of, I don't know how you always did it, right of common, I don't know, you know the term, which actually also helps you. So maybe you're afraid someone would patent you away, but if you can prove you always do it this way, then you don't even necessarily have to patent it because you can prove I already did before someone patented it.
Yeah, it's a kind of customary law then, and you do not infringe if you've done it before the patent is actually filed.
But it's a very limited, at least in Europe, it's a very limited right. And once you would use it on a much larger scale or even license it, then it's a different situation. Another point I would like to mention is that filing a patent application too early is also very risky, because at the time of the filing or priority filing, it needs to be somehow presented in a way that makes the effects that you claim credible to the skilled reader. So a mere speculation is not helpful in a patent application. You need to some degree reduce it to practice.
So better no armchair inventions.
Brilliant. Any other questions from the audience? Going once, going twice. Well, if there's no more questions, then maybe we can get some time back on our calendars. Just want to thank everyone for coming. Want to thank our incredible panelists, Tillman, Rich, Andreas, Christian, Anna, and the whole Vossius team for supporting this webinar series and supporting Nucleate's open access mission. Really excited to see all of these faces on the call today and hear so many great questions. I certainly learned a lot. Yeah, if you guys are interested in scheduling those office hours, do take advantage of that. The team would love to chat with you and provide some more specific insight into your questions and technology. And with that, we'll sign off. Thank you all very much and wishing everyone a pleasant end of their week.